This is the third screenshot video that I'm putting up in connection with the topic sources of the law. The second video, which presumably you've looked at before this one, focused on judicial authority, and more specifically, it identified two different ways in which judges in the American legal system are lawmakers. Number one, judges make the law, we said, when they interpret other sources of legal authority. And number two, judges make the law when they engage in what I've described as the common law process. In this video, we're going to explore how judges answer questions of law, whether those questions of law arise under the interpretation of other sources of legal authority or in the common law process. And I've called it the model of judicial decision making. And there are two key understandings that we really need to start with. Number one, judges operate in the context of a lawsuit, so that whenever a judge in the American legal system is doing business, that judge is presiding over a lawsuit. It could be a civil lawsuit, it could be a criminal lawsuit. And what we have to first appreciate is that in a lawsuit we can have questions of fact and questions of law. As I have said here, a lawsuit can be thought of as an event that contains factual questions and legal questions. Typically in our system, judges answer legal questions and juries answer factual questions. It's possible to have a trial without a jury, in which case the judge is answering both the legal questions and the factual questions. But our focus here is what happens in every lawsuit, and that is judges are called upon to answer legal questions, or if you will, they decide legal questions. So that's part of the first understanding. The second understanding is that our court systems are layered, meaning we have, if you will, lower courts and higher courts. And in New York State, by way of example, we have at the lowest rung on the ladder, which hardly means it's an unimportant court, but just in terms of a lower court, we would have Buffalo City Court. And we could work our way up to an intermediate courts, and ultimately we end up with the highest court in New York, our court of so-called last resort, which is the New York Court of Appeals. If we looked at the federal system, we could see on the lowest rung of the ladder, again, hardly unimportant, would be our federal district courts. And we'll talk more about the court systems in later material, but I just want to set it up a little bit now. And we then, in the federal court system, if we went up the so-called ladder, we would find that at the top of the ladder, so to speak, is the highest court, the United States Supreme Court. So we've got judges deciding questions of law. We've got the court system that is layered. And then our second key understanding is a definition of precedent. Precedent is a past judicial decision that has decided the same, or essentially the same, question of law that has arisen in our present case. As we go a little bit further in this explanation, I'll talk about the United States Supreme Court and the abortion issue, because it is so topical that a lot of us, simply by reading or watching the news, have a feel for it. But let me get down to maybe a more mundane example. Let's assume we have a hypothetical law firm, and tomorrow we have coming in, I'm doing this on a Sunday, so I'm thinking tomorrow, Monday, we have someone coming in to see us, a potential client, and that person has told us that she was severely injured by her neighbor's dog. And so one of the things that I would want to know, just to be able to elicit relevant factual information from the person when they come in, I want to know what the legal standard is, or dare say, the rule of law that governs the legal standard for when an owner of a dog is liable for injuries that the dog has caused when it has attacked or bitten someone. So what I'm going to do in all likelihood, because I've had these cases in the past in my life as a lawyer, but it's been a while, I would certainly want to look into the law, so to speak, or if you will, fancier term, do some legal research. And I would be looking for a judicial decision in the state of New York where that question has been addressed. And now let's just sort of fast forward. If I bring a lawsuit on behalf of this injured person, that case, if I have found one, or cases, if I have found them in New York, that set forth the legal standard or rule governing the liability of a dog owner for a dog bite, those cases would be considered precedent for the question of law in my case as to the legal standard. So, if you will, lawyers, and I don't think lawyers when they're doing legal research are necessarily saying, I'm looking for precedent or go find me precedent if they're being given that assignment. But that's what they're doing. They're looking for precedent. They're looking for a past case involving the same question of law. They're also looking for factual similarity because every question of law is informed, certainly, by factual circumstances. So that's our definition of precedent. A little bit more about that later, but that's at least gets us started with a working definition. And let's talk a little bit more about these layered courts. If we're involved in an actual lawsuit in a trial court, and that lawsuit ends without a settlement, but a decision has been reached, we're going to look at the possibility of the party who did not prevail appealing. And what does that mean? An appeal is going to be that party who has not prevailed, or where I grew up, who lost, is what we would say, that party going to a higher court. We could call that higher court an appellate court, and asking that court to overturn or modify the decision that was reached in the trial court on the ground that the trial court judge made an error when she decided a question of law. So that's, again, the setup. We've got a question of law, we've got layered courts and the possibility of an appeal, and that'll now give us what I've called or termed the three rules of precedent. The other point I just want to make before we launch into these rules is that notice how my understanding of precedent, even before bringing a case on this person injured in a dog attack, notice how that's going to guide my ability to determine if the person has a valid claim. It's going to guide my opportunity or my ability to ask questions, and clearly it's going to guide my recommendation as to whether or not a lawsuit should be instituted, or at least a claim asserted by a letter to the owner of the dog or whatever. So this idea of the model of judicial decision-making and precedent certainly is a lot more than some academic exercise, but it really gets us inside, if you will, the heads of attorneys and judges as they're going about the business of handling lawsuits. So what we end up with are three rules of precedent. And the setup here is we have a present case. We have a question of law. Precedent has been discovered. Key question: how much weight must the judge give or the court, if it's a multi-judge court, must that court give to precedent? And we have three basic rules. Number one, if the precedent is from a higher court, it must be followed. Two, if the precedent is from a lower court or a court from another jurisdiction, the judge or the court in our case doesn't have to follow it, but can look at it and it might consider that precedent from a lower court or another jurisdiction as persuasive. Thirdly, if the precedent is from the same court, it should be followed unless there is a compelling reason not to follow it. I just checked the time remaining. The system I use, it's 15-minute videos, which almost always works for me. But I think that I'm going to bump into the end of this one before completing the screenshot video, so I'll just go into the next one when that occurs. And if I seem to end this abruptly, I'll stitch it together in the next video. What's kind of interesting, the material I have up now was prepared by me before the Supreme Court this summer, and the Dobbs decision overruled Roe versus Wade. So we have some added historical stuff that I can put into this explanation. So when I wanted to illustrate the three rules of precedent, I identified a constitutional question of law. Again, it doesn't have to be a constitutional question. It could be a question of law about the legal standard for assessing the liability of a dog owner for the dogs attacking someone. But this happens to be a constitutional question of law. And we had the 1973 decision of the Supreme Court in Roe versus Wade in the rule of law that was announced, namely that a woman has a constitutional right to privacy, which includes her right to obtain an abortion without undue state restrictions, at least during the first 2 trimesters of pregnancy. The court, in later cases, particularly Planned Parenthood versus Casey, sort of massaged or modified that rule some, but Roe versus Wade was on the book, so to speak. It was precedent and remained so from 1973 until 2022. What I have in the next sentence is that when Roe versus Wade was precedent, all the courts below the level of the Supreme Court in the United States, because on questions of constitutional law, the Supreme Court's interpretation of the Constitution is binding on all lower federal courts and all state courts. So all of the courts in the U.S. were required to follow the rule of precedent in Roe versus Wade. Now let me just go up a little bit, and if we're in, as we are, that first rule of precedent, that meant that all of those courts, even if they disagreed, even if they thought Roe versus Wade was wrongly decided, were required to follow it. If you don't have something like this idea of precedent, in some circles it's called stare decisis. I don't use the term because I think it kind of clouds up the issue. But if we don't have something like these three rules of precedent, what we've got is, I think, a form of judicial anarchy. And if you have judicial anarchy, it's really an instability in the system that, in the long run, isn't going to do anyone any good, it seems. In any event, we get to when Roe versus Wade was still precedent, all the courts had to follow it. And under Rule 3, this is where it gets a little bit interesting, the Supreme Court was required to follow Roe versus Wade unless it had a compelling reason not to do so. I'm going to pick up this screenshot video and continue at this point and close this one out. Thanks.